we've had such good weather all the time, and then I go and schedule it on this week, and then 2 days after the first debate, when law people are still huddled in the law school talking about who won and who lost.
Well, I hold you personally responsible for the weather.
Yes, I do, and I take full responsibility. I'm also going to apologize to him for not reading his entire CV, because that would take up all 60 minutes of his time. So I'm going to have a very brief extract from his CV to introduce him. But the first thing I want to say is how grateful I am as director of the Humanities Center to this outstanding scholar and administrator has participated in our programs. He is currently a resident scholar for the second year. He has embellished the center's resident scholars program with his contributions. And not only that, he has been a moderator in our fall symposia and a contributor to our Brown Bag series. He's a friend of the center, and I thank him very much. Robert, he's going to talk to you today on communitarianism and the Roberts Court. He recently returned to full-time teaching and scholarship after serving almost 5 years as Dean of Wayne Law. As Dean, he led the law school in the development of a new environmental law clinic, an asylum and immigration law clinic, and a program for international legal studies. He secured funding for public interest law fellowships and assisted in strengthening the law school's dynamic faculty by hiring a number of outstanding legal scholars and practitioners. In October 2011, he welcomed more than 600 guests to campus for the dedication of the Damon J. Keith Center for Civil Rights, a project he and a number of Wayne Law faculty members, alumni and friends helped to make a reality. I remember vividly how important that was and how excited this campus was for that achievement. He teaches courses in torts and dispute resolution. He serves on Labor and Wayne's Internal Advisory Board and as Wayne State's faculty athletic representative. Previously, he served on the Institute of Continuing Legal Education's Executive Committee, chairing that committee from 2009 to 2010. For those people who don't know him, I want to tell you that prior to coming to Wayne Law, he served as a professor at Penn State's University's Dickinson School of Law, where he taught torts, dispute resolution, conflict resolution theory, negotiation, and mediation. He also served as director of the Center for Dispute Resolution. At that time, it was the nation's 7th-ranked law school dispute resolution program. His early education foreshadowed his professional success. He is a cum laude graduate of Harvard Law School and a magna cum laude graduate of Colgate University. Served as dean and professor of law at Willamette University College of Law from July 1996 to May 1999. When he was dean, the law school experienced a 60% increase in financial aid to law students, a revitalization of the alumni organization and annual giving, enhanced visibility of the Center for Dispute Resolution and Law and Government program, and an increase in the diversity of the faculty and student body. He has had wide experience. He is a lecturer at Bar Elam University in Israel, University of Vienna School of Law, the Penn State University College of Medicine, Leicester Polytechnic School of Law, which has now been renamed. He is also employed by the Denver firm of Holmes, Roberts, and Owen. and the Harvard Prison Legal Assistance Program. He has written extensively in the field of torts, dispute resolution, communitarian theory, and civic responsibility, and his scholarship has appeared in a wide variety of high-profile publications. His essay, Taking Responsibility, was a winner of the International Communitarian Essay Contest and was published in the German social science journal entitled Leviathan. His co-authored book with Robert F. Cochran, Jr., Law and Community, The Case of Torts, was published early in 2004. He's an active participant in professional groups and so on. So I could name a couple of his publications. I just named one. He's got a book forthcoming with Lance Cole entitled Making Corporate Law More Communitarian, the prose response to the Roberts Court's personification of corporations. Then he has an article entitled Justice for All, 3 Lessons in Delivering Fairness and Dispute Process to Many Parties, which was published in Dispute Resolution magazine in 2014. He has an article entitled Vanishing Trial, Vanishing Community in the Journal of Dispute Resolution. And I can go on and on, and I can also read all of these accolades, but none of this says what a wonderful colleague he is, how he is able to be both a mentor and an exemplary scholar. And the Humanities Center is very, very pleased to name him as a friend. So he'll talk to you today on communitarianism and the Roberts Court. So on this bleak, cold Wednesday morning in September, I want you to give him a warm applause as you welcome him.
Thank you very much, Dr. Edwards. I really appreciate not only the introduction, but I think this is the 3rd time I've had the opportunity to speak at Humanities Center Brown Bag, and I'm in my 2nd year serving as a resident scholar at the Humanities Center, and I really appreciate not only everything that the Humanities Center has done for me, but the work of the Humanities Center in knocking down academic silos and actually bridging across different disciplines here at Wayne State. So, communitarianism and the Roberts Court. This is about as fancy a graphic as you're going to see here, at least during this presentation. I thought this would be a good statement to lead off with. In the law, the language of individual rights comes easily, while the language of community is more foreign. Now, we after all have in the United States a Bill of Rights. Much of the litigation before the Supreme Court involves that Bill of Rights. There is no Bill of Community, although indeed one of the aims of the Constitution is to improve the general welfare. And so indeed the idea of community does very much come into our Constitution. If I were talking in China or in North Korea or in Iran or any one of a number of countries, this talk would sound a lot different, if it could sound at all. What we're talking about here is striking an appropriate balance between individual rights and the welfare of the community at large. And I think I've just mentioned a few countries in which individual rights sometimes count for very little compared to what certain folks who happen to be in charge perceive as the welfare of the community at large. And when that goes out of whack in that direction, I'm not really sure the welfare of the community at large is served. I don't think, as you'll see later, this has to be viewed as an either-or, zero-sum game type proposition. Just generally speaking, to give you a sense of what is meant by communitarianism, I've tried to, just in a single slide, try to distill some of the basic concepts. Communitarianism seeks a balance between individual rights and general welfare. It recognizes that with rights come responsibilities, recognizes the value of intermediate communities, and is inclusive, not exclusive. So, you know, intermediate communities can mean a lot of things, from as small a unit as the family, you know, to various associations, churches, religious communities, labor unions, corporations, civic organizations, what we call civil society. Those are all intermediate communities. Notice none of them are even government organizations. Intermediate communities through which we organize a lot of our activities and through which we get a lot of meaning in our lives. I threw in Amitai Etzione's name there, and one of his major works. Etzione is probably considered kind of the godfather of American communitarianism, although there are others, very notably Robert Putnam, who is no stranger to this campus. So what I'd like to do, what I'm trying to do in this piece, is apply this communitarian philosophy to the work of the Supreme Court, in particular the work of the Roberts Court. It had its inception really in my work on Citizens United and Hobby Lobby. That corporate communitarianism article that you heard Dr. Edwards cite really had its origin in the Citizens United and Hobby Lobby cases. These are cases that essentially expanded the rights of corporations and could be viewed pretty much as anti-communitarian because of what they do to certain statutory enactments that most of us, at least many of us, would regard as real communitarian efforts, whether it involved election communications and the regulations of that, or Obamacare. I ventured into that in large part because I had a partner, Lance Cole, who's a former colleague of mine at Penn State, who has a great deal of expertise in corporations, which is not an area of expertise of my own, and a dabbler's interest in communitarianism. And so we thought we could kind of meld our areas of expertise and come up with this. In the course of this, though, I was thinking more and more about the communitarian implications of the work of the Supreme Court, in particular the Roberts Court. And somewhere along the lines, the District of Columbia v. Heller case came down. You will recall that Heller was the case where the court really for the first time said that the Second Amendment's right to bear arms, I always confuse it with the right to arm bears, the right to bear arms extended beyond just the militia and was an individual right to bear arms. That struck me as a very anti-communitarian case. In other words, it was elevating the rights of individuals as against perhaps the security of the community at large, and taking a constitutional amendment that had long been viewed as supportive of really an intermediate community, that is the militia, and like organizations, and now is saying you too, individuals, have this constitutional right. A little more on that later. And so I started to consider whether the Roberts Court was about the most anti-communitarian Supreme Court in history. And these were not the only cases, but these cases started to generate that idea on my part. And then the more I looked at it, the more I realized that I was perhaps painting with too broad a brush. Okay? For example, there are communitarian aspects of the Citizens United case. After all, Corporations are intermediate communities. Labor unions, which are also protected by Citizens United, are intermediate communities. They are means by which individuals try to band together with some common goals that they might not be able to pursue nearly as effectively if they tried to do it alone. And that recognition of that intermediate community may in fact be of some significance. The Sebelius case, the case that essentially saved Obamacare, although it took some shots at it and pared a few pieces off. As strange as the manner in which the majority came together, Sebelius nevertheless preserved what I view as a communitarian piece of legislation, notwithstanding what I think are some real shortcomings of Obamacare. And fast forwarding, because there are a few other cases in this regard, fast forward Obergefell v. Hodges, for reasons I'll talk about in a little while, I view as really, in a sense, the ultimate pro-communitarian type of case. So, let's talk about some of these communitarian principles and some cases in the context of those principles. So, first of all, the expansion of rights. Okay. We have seen in the work of the Roberts Court at least some cases that have seemed to expand constitutional rights, often to folks who were not previously exercising these rights. So, Citizens United, corporations have First Amendment rights. That's really nothing new, by the way. I cite as an example New York Times v. Sullivan. That, of course, is the very famous defamation case in 1964, in which the court said that corporations, like the New York Times, in fact, they don't even dwell on the fact that the New York Times is a corporate entity. They assume that if you and I have certain First Amendment rights, that the New York Times certainly as a media organization has First Amendment rights with respect to their ability to print and publish information that may be defamatory, and that there is something of a shield of protection such that they can even say some things that are not entirely true and yet receive constitutional protection. So those people, and when I say those people, a lot of them are people who share my own political views, but those people who would scorn Citizens United because it's granting First Amendment rights to corporations might be asked what they think about New York Times v. Sullivan, which of course was widely heralded in liberal circles. Okay. Hobby Lobby, recognizing that corporations have religious rights. Now, let's be careful here. Hobby Lobby is not per se a First Amendment case. It actually arose under a statute, the Religious Freedom Restoration Act. Okay. But nevertheless, here, I think really for the first time, the court recognizes that corporations somehow may exercise religion. I mean, to some of us, that really seemed like an oxymoron. And the dissent says as much, this notion that, people exercise religion, people pray, people believe in God, people engage in religious rituals. Now, it's not the kind, unlike, say, the publishing of an advertisement, which is really what the Times was publishing in New York Times v. Sullivan. That you can see as a corporate activity. It's very hard to capture religion, the practice of religion, the exercise of religion, if we want to use First Amendment language, as a corporate activity. And then District of Columbia v. Heller, extending the Second Amendment rights to individuals, not just the militia. Here's what I see as particularly pernicious about Heller. Citizens United and Hobby Lobby, while expanding rights, did so for intermediate communities. As I suggested earlier, there is kind of a bright side, you might say, to Citizens United and Hobby Lobby. In that, it's not a bad idea to say that certain First Amendment rights, certainly rights of expression, might be obtained through corporations, through groups of individuals, as opposed to having to do it just by yourself. Okay, and even Hobby Lobby, I mean, we do recognize religious organizations as intermediate communities, and maybe very important intermediate communities. My co-author, Bob Cochran, who in some respects has very different political views and different views on religion than I do, nevertheless shares with me this notion that sometimes our religious practices should be brought into the marketplace, that there are certain ethics and morals that they teach us, and to bring that into commerce may not be an altogether bad thing. Now, we heard a presidential debate on Monday night in which one candidate harshly criticized the other for availing himself of certain things that he was allowed to do under the law, like taking bankruptcy, which may have left his creditors unpaid, and questioning the ethics of those types of business practices. Okay? Not because they were necessarily illegal, although certainly the gentleman's been accused of some illegal business practices, but because nevertheless there was some sense of morality, which at least some of us obtained from our religious teachings, that suggested that this is not the way you treat other people who work with you. Okay? But you see, while Citizens United and Hobby Lobby, while expanding rights, did so for intermediate communities, Heller took what we thought was a community right and applied it to individuals. See, so it's very hard to find redeeming communitarian elements to a case like Heller. And of course in Obergefell we have an expansion of marital rights to gay couples. Okay. Now, why is it necessarily a bad thing to expand rights? Well, it isn't. It isn't per se a bad thing to expand people's rights. What communitarians care about is the minting of new rights without concomitant responsibilities. This notion that as Americans, we're roaming out there, just as individuals, and we get to claim rights, but we owe nothing to nobody. Okay, that we're just these autonomous individuals, and we get to do whatever we want to do, and you'd better not, don't tread on me. It's kind of the flip side of e pluribus unum, right? Okay, so it's a little different than that expression by the late Yogi Berra, which I regard as really the communitarian ethos. You remember what Yogi said: you go to somebody's funeral because someday you'll want them to come to yours. Right? And that's more of a communitarian sense. You have this obligation to other people. Bear in mind, not all those obligations, in fact, most of those obligations are not inscribed in law, but some are. Paying our taxes, serving in the military, at times of the draft at least. We do have some obligations that the law does impose on us from time to time. So Citizens United, Hobby Lobby, and Heller all expand rights at some cost to others. Okay? In Citizens United, now certainly if you hear the political rhetoric, if you hear Bernie Sanders, if you hear Hillary Clinton, they think this has done real damage to our electoral process. Hobby Lobby, I don't know how many of you are familiar with the Hobby Lobby case. This was one of many attacks on Obamacare. And the regulations promulgated under Obamacare essentially said, among other things, that employers purchasing health care plans for their employees were obliged to purchase plans that included birth control devices. Okay. And on the list of birth control devices was a device that people of certain religious beliefs thought was really not just a form of contraception, but a form of abortion, and therefore contrary to their religious beliefs. And so they wanted essentially to opt out of this requirement to purchase that portion of the health insurance for their employees. Okay. The thing is this: if you rule, as the Supreme Court did, that yes, their rights under the Religious Freedom Restoration Act required that they be allowed to opt out of paying for that, well, somebody's got to pay. Either the employee's got to pay, or the government's got to pick up the slack, which is what the court suggested in the opinion. Now, as a practical matter, there isn't much slack to pick up. Why? Because the cost of contraception is a lot less, by and large, than the cost of the alternative. Taking a pregnancy to term and having childbirth. And so actually there's no additional charge to have contraception coverage on your insurance plan. So whether there's really any additional payment involved, good question. And so this may not have actually imposed too great a burden on others. Okay. Heller certainly expanding rights at a cost to others. That is, the interest in protection from gun violence is something that I don't think I have to elaborate on. Okay, compare Obergefell with that. Okay, Obergefell is a case that expands rights, but really at no cost to anyone else. Right? The fact that gays can marry doesn't mean that opposite-sex couples are losing any rights. It's not, it's not diminishing the importance of our marriages. It's just according a right to somebody else. Okay? Yeah, there may be an occasional clerk in Kentucky who may object to issuing a marriage license, and just today, the Chief Justice of Alabama is once again up on ethics charges with respect to his ordering the courts in Alabama essentially not to obey Obergefell. Okay, but in both of those instances, we're dealing with public officials in the course of carrying out their official duties. Now, we're not talking about subverting any individual's rights. Moreover, Obergefell strengthens a very important intermediate community, the family. I mean, who can object to affording to gay people an instrument that allows them to build stronger families that will protect children that much more, provide some permanency and structure to their lives. This is a good thing in terms of communitarian values. Okay. Communitarians also think there should be an element of deference to carefully calibrated legislative solutions that are enacted to serve the community at large. Okay, so we see a problem with Citizens United in that regard. There's some bipartisan legislation to govern political campaigns now that was really forged out of a bipartisan consensus and very, very carefully tailored by Congress. to try and do that. And the Citizens United case says, the heck with this. The First Amendment really makes that effort of little effect. I shouldn't say little effect because it didn't knock the entire act out. Parents involved in community schools, the Seattle School District No. 1 and Meredith v. Jefferson County Board of Education, these were companion cases involving school integration plans in Seattle and Louisville. Seattle, Washington, and Louisville, Kentucky. Okay. These were plans that were heavily negotiated. I mean, you can imagine in a good-sized school district like Seattle, well, not just Louisville, it's all of Jefferson County, Kentucky, the kind of painful negotiations that had to go on, the consensus building that went on, to try, and in Louisville, this is after the expiration of a court order mandating school integration. Okay. The very careful and negotiated effort to try to achieve or maintain racial balance in the schools. Okay. All torn asunder because, yes, indeed, they did take race into account with respect to school assignments. Now, I think you might be able to question how carefully calibrated these plans were. Both districts classified race in binary terms. Okay, in Seattle, you were classified as either white or non-white. In Jefferson County, you were classified as either black or other. Okay, I think that's particularly problematic in a place like Seattle, where there's a very heavy Asian American population, some Latino population. I mean, the use of these binary terms is a little bit disturbing, and you wonder just how carefully calibrated all of this is. Okay, and some people might find that really objectionable. And yet, both of these were earnest efforts on the part of members of the community, in at least one case, to supplant what a court had ordered them to do with respect to integration. So you're saying, gee, a community cannot do voluntarily something very much akin, it was almost identical to what a court had previously ordered them to do. Seems to me as if that's rather anti-communitarian in and of itself. Okay. Now, compare that to Sebelius. Okay, Sebelius, which was the major challenge to Obamacare. Yeah, it did pare out some pieces of Obamacare, but it did keep the major provisions intact. Okay, and it did so even although, if you read the opinion, the opinion starts off with Chief Justice Roberts talking about all the reasons why this is a serious problem. That is the government commanding us to buy health insurance, that is a serious infringement of liberties, and people are worried, oh, gee, what's going on here? What's going to happen to the Commerce Clause? And then he hits us with a whopper and says, but the government has the power to tax. The penalty charged for not subscribing to health insurance is really a tax, and therefore, never mind, you can do this. Weird way of building a majority, but nevertheless, there is a majority here, and it saves what I have to view as, while a flawed piece of legislation, still a piece of legislation with very communitarian ends. This notion of let's get everybody into the pool and insured is certainly a communitarian objective. Whole Woman's Health v. Hellerstadt, that's the Texas abortion restrictions case that was just decided last term. Okay, You'll recall in that case, yeah, it does involve legislation. It involves legislation that was declared unconstitutional, but it would be very hard to say that that was a carefully calibrated legislative solution. There was a legislative rationale of protecting women's health, but that was really a pretext for restricting access to abortion. It was very not too difficult to expose it as that. And so you can't really justify that as a carefully calibrated legislative solution. The court saw what it was, called it what it was, and struck it down. Inclusiveness and access are important to communitarians. Okay? Yes, we believe in intermediate communities, but we're wary of what we call the dark side of communitarianism. So, you could, if you wanted to strain at it, you could call the Ku Klux Klan a civic organization and an intermediate community. But the Ku Klux Klan is an exclusionary organization. The Ku Klux Klan is a group that spawns, what shall we say, strong out-group antagonisms. Okay, and so that's not the kind of intermediate community we're likely to want to encourage. Okay, rather we do care about inclusiveness. We like to talk of ourselves as a community of communities. Okay, and there are a number of decisions of the Roberts Court that run counter to this notion of not only inclusiveness, but what I'll call access to legal remedies, for example. Okay, so the parents involved case, which was a case that was trying to assure students access to good schools, notwithstanding their racial classification or where they happen to live geographically, it seems to me as if that was a case that ran counter to the notion of inclusiveness and access. Shelby County v. Holder, of course, that's the case that upended a critical section of the Voting Rights Act of 1965. We've seen since that time, it's been demonstrated in many situations that indeed that opinion has served as a means to try to restrict access to the voting booth on the part of minority communities. Both of those cases can be criticized as falling prone to excessive formalism. Okay, my colleague Steve Winter has written a very good article about Justice Roberts in particular's excessive formalism. Parents involved is the case in which he says the way to stop discriminating on the basis of race is to stop discriminating on the basis of race. Okay. Sounds very nice, but it really doesn't hold up if you scrutinize what's really going on in the schools of Seattle and Louisville and any number of communities in this country. Detroit probably being a very good example. Okay. Then there are a number of cases that I might call procedural cases. Iqbal, which tightened up on what we thought were notice pleading requirements and required more specific forms of pleading. The Walmart case, which made it much more difficult to certify a class action, in that case a class action based on employment discrimination. And then there's a series of arbitration by ambush cases. Some of them reach to a period before the Roberts Court, at least into the Rehnquist Court, in which people, they may be employees, they may be consumers, have fallen prone to arbitration clauses that they didn't even know were in their employment contract, their credit card contract, what have you, and have been forced into arbitration based on the Supreme Court's, I have to say, rather extreme reading of the Federal Arbitration Act. These are not, for the most part, constitutional cases, although the dissenters might suggest that there are some kinds of access to justice issues that might rise to constitutional concern. They're, for the most part, statutory interpretation cases, but the court chooses a form of statutory interpretation that denies a large number of people access to the courts. Okay? Again, compare Obergefell, if you will. That strikes me as a case very much in favor of the notion of inclusiveness. Okay. A little bit more about intermediate communities. We've talked about that in the context of Consumers Union and Hobby Lobby, how there may be a silver lining to those cases in terms of the rights they accord intermediate communities. But the very same day that the court issued the Hobby Lobby opinion, it also issued the opinion in Harris v. Quinn. How many of you have even heard of Harris v. Quinn? Now, it was kind of one of these below-the-radar cases. Okay. Harris v. Quinn involved some home care workers who were paid through the state of Illinois. So in a sense, they were state employees, but they were public employees, but in a sense they weren't. They went and worked in people's private homes, and there was, I think, a federal grant that went through the state of Illinois. Okay? And there was collective bargaining for the terms of the contracts of these people with the state of Illinois. Okay? The plaintiffs claimed that being forced to pay a service fee to the union that engaged in collective bargaining on their behalf was a violation of their First Amendment speech and association rights. Now, those of you who are on the faculty here know that whether or not we belong to the faculty union, we pay a service fee, essentially, to the union. Those of us who belong to the union pay an additional fee, okay, that's supposed to cover the political activities of the union. But because all of the faculty are represented by the union, all of us have to pay a service fee for the union's representation in collective bargaining and grievance procedures, etc. Okay? This is what was being attacked in that situation. The interesting thing for us in particular is that the leading case on this issue is Abood v. Detroit Board of Education that said that that was perfectly fine to require all of the people in the bargaining unit to pay this service fee. Okay? In Harris, the court says, well, if we're talking about bargaining with a public entity for public employees, although these were not quite public employees, it involves public issues, even almost anything that comes up between a public employees union and the employer involves public issues of some sort, and therefore First Amendment rights. Now, how much is going to be paid for my salary? Okay. What other contract rights members of the faculty may have? That all involves First Amendment concerns because it's public dollars and public policy involved. And so the court says the payment of this service fee is a violation of the First Amendment rights of these employees. Now, it's careful to contain its opinion to apply only to the special kind of circumstance, okay? But you could feel what was coming, and what came was this year. The Friedrichs case went up to the Supreme Court, much broader case involving teachers in California, which, if the plaintiffs had had their way, would have essentially imposed right to work, I like to call it right to freeload, as a matter of constitutional law with respect to all public employees. Okay. Now, what happened to the Friedrichs case, which folks thought was going to, once and for all, overturn Abood. Well, Justice Scalia died. It became a 4-4 case. The ruling below preserved the scheme, preserved what's sometimes called the agency fee. Okay, and so we still have we still have the mandatory use of the agency fee. To me, this is a kind of important case because I had always learned that a basic tenet of industrial democracy was you throw in your lot with your coworker. And even if you're a dissenter, if your coworkers, if a majority of your coworkers vote to choose somebody as your agent for collective bargaining, you're all in it together. Now, and that union is representing all of you together, and in fact is obliged under the Wagner Act to provide full and fair representation to everybody in the bargaining unit. Okay. And now we're saying you have a constitutional right to opt out, not just out of paying the part of the union dues that go to political activities, but to opt out of paying all of your union dues. Now, all of the fees, including those that are being expended to represent all of the members of the union. To me, that's a matter of really serious concern. We dodged a bullet this year with Friedrichs. We'll see what goes on. I find it very interesting when at the same time the court is upholding this notion of collective rights in Hobby Lobby, and shortly after it had done so in Citizens United, it's ignoring the collective here in favor of what it claims are the individual's First Amendment rights. Okay? Robert Putnam in Bowling Alone talks a great deal about how unions are a very important but disappearing intermediate community. And there is a national assault on unions, public employees unions in particular, but unions in general. The right to work, so-called right to work legislation that was enacted here in this state a few years ago is an example of that. There are those of us who like to think that individual rights and the general welfare is not a zero-sum game. A friend of mine, Bernie Mayer, who's more known in the conflict resolution community, has recently written a book, The Conflict Paradox. He talks about seven paradoxes that arise in conflict, where people tend to say, well, it's either this or that. Mayer is trying to say that ain't necessarily the case. The one that's of most concern to us here is the paradox of autonomy versus community. There are those of us who'd like to say, no, we can emerge from a zero-sum game there. Okay? The opportunities for the courts to craft win-win solutions with respect to autonomy, i.e. individual rights, and community, are probably a lot more limited than for the executive branch, than for the legislative branch, which can kind of craft solutions along these lines. It's a lot tougher for the courts, but there are some examples. The least restrictive alternative rule in First Amendment cases, where the court says that government has to employ the alternative that is least restrictive of First Amendment rights. That could be speech, that could be religion. That strikes me as an effort to build a win-win solution. McCutcheon is not a favored case for liberals, okay? But nevertheless, it talks about how disclosure requirements in federal election laws may be viewed as the least restrictive alternative in terms of regulation. Zubik v. Burwell is really kind of son of Hobby Lobby. It's kind of the follow-up case. Okay, in Zubik, some religious adherents said, not only does our religion prohibit us from paying for the contraceptive care that was discussed in Hobby Lobby, it prevents us from even filling out a form saying that we're opting out. That our filling out the form saying that we're opting out, as Hobby Lobby allows us to do, is too much cooperation on our part with the abortion machine so that it offends our religion. Now, seems a little strange to me, okay? But nevertheless, that was the claim. Zubik was yet another case that was not decided by the Supreme Court this year. Why? Because of the death of Justice Scalia. So again, and I could say because of the Senate's refusal to confirm a replacement justice. But in any event, Zubik is not decided. It's remanded, and in the little note that the court writes on remand, says, you know, it's our understanding that there are some procedures that the government has talked about and that the plaintiffs have talked about that might allow for a mutual accommodation here, and we strongly urge you to talk about those procedures. No hints as to which way we're going to go on the case, but you might try and do that. So there was the court at least trying to get the parties to go for some kind of a win-win resolution of this. So, in short, a communitarian view of constitutional adjudication would encourage and support the American experiment in liberal democracy. That sounds to many people like just a rehashing of what some people would call the knee-jerk liberal take on the Supreme Court's work. I'd like to think that it is not. Okay? A look at some of the court's criminal procedure cases might bear that out. I won't go into detail about Herring v. United States, but that's a search and seizure case in which I end up siding with the court's majority and not with Justice Ginsburg, who thought that this search was too compromised, and you know, for reasons I'm happy to spell out with you, but we are running short of time. I think communitarians in a lot of these cases would avoid gamesmanship, gotcha rules that I think we sometimes see in post-Miranda cases. Currently, I think the use of the exclusionary rule combined with restrictions on civil actions result in a lose-lose situation. The people lose their evidence. You know, if you obtain, you know what the exclusionary rule means. If you obtained evidence in violation of Fourth Amendment rights, you can't use the evidence. Okay, so the people lose their evidence, okay, which is bad for all of us. Okay, this might be evidence that might convict the bad person, okay, of a crime that they did commit. But the exclusionary rule shuts out the evidence. But the people who have infringed constitutional rights don't pay the price most of the time because of all the immunities to civil liability that we've imposed. There are only the narrowest situations where public officials who have violated constitutional rights actually have any exposure to civil liability. To me, that's the worst of both worlds. We lose the advantage of evidence that might help in a criminal prosecution, okay, and yet we don't build in the disincentive of essentially what we call tort liability, or civil liability of public officials who are abusing constitutional rights. Okay, admittedly, I have to give a lot more thought to that, but that's where at least I tentatively stand on that. And there was at least some note by Chief Justice Berger years ago that was kind of supportive of that idea. Okay. Why does this matter? And I ask this question seriously. Okay, you know, all this may be is, you know, trying to satisfy the fact that I tend to look at a lot of things through a communitarian lens. Okay. And perhaps it means nothing more than that, and it's satisfying one academician's sense of what lens he likes to look at things through. I'll suggest a few things that might make it matter. I regard the Supreme Court as potentially our national consensus builder, as a setter of community norms. I can think of no case that represents that more strongly than Brown v. Board of Education, that essentially said apartheid is not who we are, that we cannot have public discrimination on the basis of race. So I think there are certain community norms to which most of us subscribe, to which the court subscribes, that we are a community that respects individual rights. We are also a community that promotes the general welfare. Finally, we are an inclusive community of communities. And if you look at the landmark decisions of the court, the ones that have held water, the ones that have meant the most to us, the cases like Brown v. Board, I think those are the kind of things that they said. Now, the court once had a broader center. There was a lot more consensus on the court. The decision in Brown v. Board was unanimous. Not only that, for many years thereafter, I think through the remainder of his term as Chief Justice Warren tried to make sure that all of the court's school desegregation decisions were unanimous decisions. This was a big change that was going on in society, and he had to show that the court represented a united front. And I don't think that's the only time the Chief Justice has taken on a responsibility as a forger of consensus. Dickerson v. United States, probably not a very well-known case, but it's probably best known for Chief Justice Rehnquist, who of course had represented the court's far-right wing when he first came on the court as an associate justice, now saying, yeah, Miranda is kind of accepted, not only as the law, but as part of our culture, and you can watch any police procedural and you'll know what I mean, and subscribing to this, and it's all just part of the consensus of what rights are in America. And even what Chief Justice Roberts did in Sebelius. I can't help but think that he's saying, okay, I want to preserve this concept of not forcing people to do things, but I can't upset this entire apple cart. I am the Chief Justice. I'm not going to dump over the entire Obamacare apple cart. I've got to figure out a way to see. Now, the problem is, of course, these tend to be 5-4 decisions now in a lot of these cases. It's hardly consensus. Justice Sandra Day O'Connor and Anthony Kennedy have often been that middle vote, that swing vote. I think they too have often been very conscious of this notion of trying to forge some kind of national consensus. Okay, I know that Justice O'Connor would take a lot of heat for supposedly not having a consistent judicial philosophy. Well, I think she was fairly consistent in her respect for the work of the legislature. And I think more importantly, she was consistent in trying to figure out, okay, what are the threads, the common threads that I can grab a hold of that represent, the middle, because the center must hold. Likewise, I think Justice Kennedy, as much as I might criticize him, after all, he is the author of Citizens United, Justice Kennedy was also the author of Obergefell v. Hodges. And here's the last paragraph of his opinion. No union is more profound than marriage, for it embodies the highest ideals of love, fidelity, devotion, sacrifice, and family. In forming a marital union, two people become something greater than they once were. As some of the petitioners in these cases demonstrate, marriage embodies a love that may endure even past death. It would misunderstand these men and women to say they disrespect the idea of marriage. Their plea is that they do respect it so deeply that they seek to find its fulfillment for themselves. Their hope is not to be condemned to live in loneliness. Excluded from one of civilization's oldest institutions, they ask for equal dignity in the eyes of the law. The Constitution grants them that right. Their hope is not to be condemned to live in loneliness. Now, what a communitarian expression on the part of the Supreme Court of the United States. So, bearing in mind the fact that my professed area of expertise is not constitutional law, take some shots at this. Not applause. Take some shots at this, if you will. Is this just a rehashing of knee-jerk liberalism? Or is there something else to this?
I have a question about Hobby Lobby. Was that a closely held, privately held company or publicly held?
In our article, we go off on this quite a bit. It was not publicly held. It was what you might call a family corporation, okay? Now, you got to be careful. There are closely held corporations. There are sub-S corporations. There are, privately held. There are all different types of corporations, which my co-author gets into in a great deal of depth in the article. But it really makes a difference because we would agree that if the holding of the case is limited only to, say, a closely held family corporation with all of the shareholders subscribing to the same religious tenets, then there may be very little harm in all of this. Okay? As distinguished from a privately held corporation, you'd be surprised at some of the corporations out there that are privately held. Cargill, one of the biggest agribusinesses in the country, they're not public. They're not a publicly traded corporation. They're a privately held corporation, but they're a huge corporation with a huge number of employees. Okay? And now you're saying that corporation has religion? Now, that's troublesome to us. So we would like to think that all they mean is this very closely held family or very close to family corporation, which all the shareholders and perhaps all the employees subscribe to certain religious tenets. And probably also very small, because once you get a certain number of employees, you may have some problems engaging in religious discrimination, among your employees. Particularly, the problem for Hobby Lobby was that it was not a religious organization. Okay? There was already an opt-out in the regs for religious organizations, like churches, like Catholic universities. Notre Dame is a prominent example of that. Okay? They had an opt-out built in. They're a religious organization. Okay? These are not religious organizations. These are corporations that claim to have religious scruples. Think Chick-Fil-A.
Looks more like private rights than an intermediate communal organization.
Well, what I would argue is this whole notion of a corporation having religion, exercising religion, is an oxymoron. Nothing, what could be more private or right than your exercise of religion? Sure, you might gather with your co-religionists to do it, but it's your private religious decision. I think I agree with you there. As individuals, they can claim RFRA rights and a right of free exercise. How does a corporation claim a right of free exercise? That seemed to be what was pretty much out of whack, at least at first glance at Hobby Lobby.
Question over here.
Yeah. Is there?
Oh, I'm sorry. Roe v. Wade, what was your opinion? Did you agree with the decision on it? I know it's a long time ago.
Yeah, Roe v. Wade. Roe v. Wade is complicated for a lot of reasons beyond communitarianism. My view is, and this is real, I really haven't thought much in terms of communitarian analysis with Roe v. Wade, as distinguished from, say, some of these subsequent cases that Roe v. Wade has an impact on. You notice Roe v. Wade, even though it may be the most discussed case of the Supreme Court, has not garnered behind it the national consensus of Brown v. Board of Education, or even Miranda. Okay? And my own thought is that the court maybe went a step too far. That there was a tendency, you may recall historically, no, you're too young to remember that, but I remember, there was a tendency at that time, more and more state legislatures were opening up to legalized abortion, okay? And now Roe came in and started talking about it as a constitutional right. And the court embraced that without articulating it very well, in my view. And as a consequence, never developed a national consensus over it. Compare that to Obergefell, in which, again, a number of states were starting to drop their gay marriage bans, and public opinion suddenly shifted in the course of 10 years, overwhelmingly. I don't know, how many of you remember that Bill Clinton signed the Defense of Marriage Act, which was overturned in the Windsor case, which was the precursor to Obergefell. So suddenly we've got this national consensus developing over gay marriage, and the court hops on the train and says, okay, with a sweeping decision. But I think that's going to cause in the long run a lot less in the way of problems than Roe. You'll hear some people squawking about Obergefell, but even now, even at the Republican convention this year, still more squawking about Roe than about Obergefell.
If the Friedrichs case had made it to the Supreme Court, what?
Excuse me?
If the Friedrichs case had made it to the Supreme Court,
Yeah.
what is the justification that they would use to distinguish a corporation from a union? Why do they treat it differently?
Well, it's a different circumstance. I'd like to say, you should look at these intermediate rights, intermediate communities, which remember, in Citizens United, that same restriction on speech applied not only to corporations but to labor unions. Okay, so you're recognizing these communal rights here, but not over here. But of course, that didn't even come up. What was the strangest to me was they said, "Now we're not overruling Abood," and they tried to say, "Well, this applies only to this semi-unique situation of these people who are technically public employees but are working in private homes." And the distinction they tried to make between that and public employees generally was a distinction without a difference. And that's why we thought in Friedrich, Abood was going to come a cropper, and that's what the oral argument strongly suggested. And then Justice Scalia died. So, depending on what happens in November, Abood may be safe or it may not be safe.
For the cases that have been deadlocked because of the death of Scalia, will they be able to revisit them or not?
Well, it really depends on their procedural posture. A lot of remember, these are all appeals, typically from an intermediate federal
I
court.
understand.
okay? And so you revert to the holding of the intermediate federal court. In some cases, it might be a state Supreme Court, okay? I think reviving the precise case may be difficult under those circumstances, but you can be sure that there are people who try and revive, the same issue. Yeah. Now, if Mrs. Clinton is elected, the people who are looking to overturn a Booth may lay low for the time being, depending on who she appoints to the court. You see, they might not want to create more precedent reaffirming a Booth. They might want to wait until the time is right for them to go after it. Do you have something?
Any other
Well,
questions?
Well, yeah. Any questions from our development office?
Oh, it strikes me from your talk that in some cases the emergence of religion into an organization can promote more of a community kind of feeling, like, care for your common man and that kind of thing. But in other cases it seems to strike as promoting individual rights. How do you reconcile?
Yeah, well, again, communitarians would say, well, we ought to take seriously these group rights, not to the exclusion of individual rights. So when, just before we completed, when we were like in the second to last draft of the corporate communitarian article, I sent the article to Bob Cochran. Now, just to give you a sense, Bob Cochran teaches at Pepperdine University Law School, okay? It's a religious university, okay? He is, interestingly enough, the Louis Brandeis Professor of Law. He's got the Louis Brandeis Chair at Pepperdine Law, which is quite interesting. When we wrote our book together, we described Bob as a conservative Republican and an evangelical Christian. We described me as a moderate to liberal Democrat and a Reconstructionist Jew. Okay, and we said, nevertheless, and we live on opposite coasts. At the time, I was living in Pennsylvania, and we said, nevertheless, we find common ground in communitarianism. Now, when I sent him this piece, I said I want to, there's some remarks he had made to me earlier about Hobby Lobby, and I wanted to make sure I incorporated them correctly and wasn't misquoting them or whatever. And he sent me an email back and saying, boy, a lot can be said for organizations that bring their religious values to the marketplace. And the organization he chose to talk about was Chick-Fil-A. Now, a lot of people will think, oh, Chick-fil-A, they're the folks who we boycotted because they were against gay marriage, right? And they had opposed Prop 8 in California and all, those kind of stuff. And he says, Chick-fil-A really tries to be ethical in all their dealings. They keep clean stores. They pay all their employees no less than $12 an hour, which in a lot of the places in which they operate, that's a pretty nice salary. They try and engage in all kinds of ethical employment practices, et cetera, et cetera, et cetera. These are people who really bring their religious values to bear, and they should be encouraged for doing so.
They're closed on Sunday, don't they?
They're closed on Sunday. Yeah. In other words, they are losing out on profits because Sunday would be a big day for them to sell a lot of chicken sandwiches, right? And this is the kind of thing that we ought to value, and we're not going to impose their religious values on all the rest of us. But some of us would think that Mr. Trump would do well to abide by some of their religious values in his business dealings. So you've got to have some respect for that. the trick, you know, it's always been a problem with the American experiment. How do we keep, you know, hold all of this together? Because there's some of us, I know for a while, my wife and I didn't go to Chick-Fil-A because of their opposition to Prop 8, you know, or maybe it was support, I can't remember which way Prop 8 went, but they were anti-gay marriage. And, you know, but damn, they make good chicken sandwiches. And the service was really good, and the people are really nice. And, you know, I can live alongside these folks.
Okay, let's stand back.